children, because most of us are here today because of our children. So I'll touch on that as well as part of my presentation.
So before she starts, can I just encourage people just to move forward, just fill up all the front rows, if you don't mind. Thank you.
Okay. The Immigration Act 2014. Not sure most of you will be aware, but there is a new act, and it affects pretty much all of us in this room here, whether we are migrants or not, whether we've been born here or whether we came to the UK a couple of years ago, or either way, we're ethnic minorities, so it affects all of us. The new act, what it does is it restricts people on employing migrants if they don't have status to be in the UK, and it restricts landlords on actually renting out properties to illegal migrants. And it also restricts colleges, and it restricts marriages, and it restricts migrants opening bank accounts or building societies or registering with the NHS or obtaining any NHS services if they don't have stay to be in the UK. So, for example, somebody could have arrived to the UK and, for example, they claimed asylum. If they don't have status of a refugee, then they won't be able to access the NHS. That's what the new Act says. A person with no leave who is required to have it may simply be removed. So before this new Immigration Act, what used to happen is that if somebody doesn't have leave to be in the UK, they'd be set with removal directions. But now, with the new Act, if you don't have leave and immigration officers notice that you don't have leave, they can simply remove you from the United Kingdom because you don't have right to be here. There's no right of appeal if you've got removal set for yourself. So before there used to be a right of appeal. Now, if they find you, they can easily just deport you. However, there is one thing that we're left with, which is judicial review. And that's if you've actually already made an application to the Home Office and it's pending and they decide that they're going to deport you because there's a decision that's not been made. Or for example, they've decided to deport you because you don't have status. You haven't made an application. So what you can do is, if you've got family in the UK, you can make an application for judicial review with the help of your solicitors to say that it's unfair for you to be removed from this country because you've got children, you've got a partner, or you've got relatives in the UK, and it will be detrimental to their lives as well as your lives if you are removed. Okay? The other thing is, who does the removal power apply to? It applies to anybody who requires leave to enter or remain in the United Kingdom but doesn't have it. So if you don't have your biometrics residence permit, as they call it, or if you don't have a red passport, effectively it can affect anybody here. Grace period when children are involved. So this is situations where, for example, a child is British. The child is British, but the mum or dad that they're living with is not British, or they're in the process of sorting out their immigration status. The immigration officers, they can still remove the person the mum or dad who doesn't have status, but if there are children involved, they have to give you 28 days to sort out arrangement for the children. For example, their other parent might be British, or they might have indefinite leave to remain, so they have to have that grace period. And in that grace period, sometimes people may want to make an application for judicial review because it's unfair for the children to be left with just one parent in a country. Because, as we rightly would want, is for our children to be brought up with both their parents in their life. Even if the parents don't get along, they should still be allowed to have both parents as part of their life as they grow up. Independent Family Returns Panel. This is a panel that's been introduced with the new Immigration Act. The Secretary of the State, the Home Office, are obliged to actually consult them before they remove families or children. However, that there is no duty for the Secretary of the State to abide by this. It's a recommendation that's been made, but the Secretary of the State can actually disregard it. I've mentioned a little bit about Section 55, so that means welfare and welfare of the children. So the Secretary of the State has to take into consideration the welfare of the children when they're making removal direction. So if there are children involved, although they have to consult that independent family returns panel, they also have to bear in mind what is in the best interest of the child. Safeguards on detention of children. It restricts detention of unaccompanied children for short-term holding detention facilities and only for 24 hours in certain conditions. So that's how long they can actually hold when there's minor children involved. Some of you might be aware, previously there used to be immigration appeals. So for example, if somebody's application at the Home Office was refused, they would be given a right of appeal. Now that's been abolished. What there is now is what's called an administrative review. So that's a review that you apply for after your application has been refused. So there's no right of appeal, it's just administrative review. It's important to get your lawyer's help because when you're applying for administrative review, you've got to make sure that you get everything in there that's not already been put in your case. So, for example, somebody who has made an application to remain in the UK as a spouse. They have no children. Their application's been refused. Sorry, I keep saying removed. The application has been refused, and they're applying for administrative review. It's important to get your lawyer's help with that because you might be pregnant or expecting a baby, but the Home Office are not aware of that. They have not taken that into consideration, so it's important to get your lawyer to help you put your case. This is your last opportunity because there's no right of appeal. So this review is essentially that gets you to be in the country if you've already been refused. British citizenship. Secretary of the State, she can order to deprive someone of their citizenship if they've acquired it by registration or naturalisation, if she is satisfied that you've acquired it by fraud, false representation or concealing a material fact. Regardless of obtaining your British citizenship through naturalisation or registration, she can still remove you from the country and deprive you of your citizenship if she's got reasonable grounds to believe that it's good for it's conductive to the public good. So, for example, if you've committed a crime that's quite serious, and you keep repeating to be behind those cells, then of course when you're out, she can practically deprive you of your citizenship. Briefly now, I'm going to touch on the immigration rule for children. So the first one is, of course, children under the age of 18. If they've continuously been here for 7 years and they're under the age of 18, they've spent their time in the UK constructively and they've got friends and family here, they've built a private life and a family life, and they attend school, of course most of them would, they may be entitled to live in the UK with mum and dad. So both parents can apply in line with their children if they spend 7 continuous years in the UK. Entry clearance is another type of application. Under the age of 18, mum or dad, or even both, if they're settled in the UK, settled is usually indefinite leave or they've got British citizenship. But it could also be instances where one parent is missing because they've never been involved. Hopefully that parent that's never been involved will have to be in the home country. And the other one who's got settlement will be here. And if they can prove, the parent here or the parents here, they can prove they've got sole responsibility and there's nobody to look after that child for one reason or the other in their home country, they can get their child to apply for entry clearance to join them in the UK. I hope that makes sense. The other one is sole responsibility for children in the UK. So entry clearance is, of course, when somebody's coming, a child is coming from outside of the UK. Sole responsibility for children in the UK is for children who are already in the UK. And what that application involves is if the child is under the age of 18, he is British or she is British and she's got indefinite leave to remain, mum or dad has sole responsibility because one of the other parent doesn't want to be involved, or for one reason or the other, they're no longer there. So you're the only person that's looking after that child, but that child is British. So of course that child has a right to be in the UK. So via their right to be in the UK, you can apply to regularise your stay. Contact with a child in the UK. So that's, of course, again, under the age of 18, a child has to be settled or has British nationality, and this is different to sole responsibility because sole responsibility is where child is in the UK and the other parent has just gone missing. This one is where, for example, one parent has sole responsibility, but of course you also want to live with that child, you also want to be involved in their life. You can apply for contact, or even the other partner. If they agree that yes, you can have contact, you don't need to go to court. You need to just apply to the Home Office to regularise your stay on the basis of your contact with that child, so that child can be brought up with both of their parents in their life. That's all. Unless anybody's got any questions. I know I've just skimmed through everything, but if anybody's got any questions, I'm more than happy to answer them.
There used to be a clause where it says you can bring people who are aged 18 and above. Is that still there, or did you?
No, you can't. Not unfortunately. Now, anybody, any child, of course, with I appreciate I'm from Asian culture, Asian and African culture. It's quite similar. Even though a child might be over 18, I'm still dependent on my mom. But here, the rules say as soon as a child is over 18, they can't be dependent on their mom and dad. There is one provision, however, between 18 to 25, if somebody spent more than half of their life in the UK, and they can prove that, that can also grant them leave to remain.
Oh, but if it's your mother, like somebody who is more than 50, because before they had that provision.
Yeah, that's no longer. If it's adult dependence, it's very difficult. You can apply for that. However, it's very hard onus to actually satisfy, because if your mother or somebody that's seriously ill, you've got to show that there's nobody practically to look after them in their home country, and they're very serious, and if they're not brought into this country, they will practically die. So those are the kind of requirements that we're looking at to satisfy in order to bring anybody. It's very strict now. It's not as simple as it used to be, I'm afraid. Any other questions? Yes?
I just want to find out, if somebody is going to grant us, let's say a 2-year visa stay, are they able to apply for university, or you wouldn't advise that?
Is the child under 18? They can apply. They can actually apply. They can, as long as they're not relying on public resources, they can still continue to study. That's allowed. Yes. Any other questions?
No questions. Rima is still around, and we do have a team from RBM Solicitors. So if you do.
Right, I've got Pastor Ndlovu, and Pastor Ndlovu spoke to us